from the lease minors under the heading order item number 96 for withdrawal.
96.
Minor.
You are for the petitioner.
Petitioner.
Mr. Kalyan Banerjee.
Minor.
Learned counsel appearing on behalf of the petitioner
Minor.
seeks permission to withdraw this petition. Permission is accorded. This petition is dismissed as withdrawn. Why are you withdrawing it?
टेक्निकल डिफेक्ट्स आ रहा जिसको विड्रॉ करके फिर लोअर कोर्ट से वो करके आए हैं.
Please quote the prayer. Any interim order there?
No, it is in the defect was
81 also the same.
Serial number?
81 is the same.
This was serial number, Mr. Banerjee?
96, my lord, it is 96.
96.
Division 1300.
Have you noted down?
Yes.
आप बताएं.
1473 serial number 81 is the same.
Serial number 81. Same prayer?
Same.
Any interim order?
No, yes.
Let these orders be communicated to the court concerned
Alright.
through fax or email.
Serial number 79.
Serial number 79, same order. You need to quote the prayer, right? Any interim order?
No.
Serial number 99 is edition. I have informed the petitioner side.
Okay, where is?
They will be present after
After what?
the order with defense. That's all.
All.
Passport case from during this at 10:30.
Serial
Item
number
51.
27. May I permitted to withdraw your lordship?
Okay. Serial number 27.
Yes, your lordship.
You are advocate on record.
Yes, sir. Yes, sir.
You have to put your signature. Same order. Communicate to the court.
Serial number 29, my lord, and on behalf of the state, my lord, I search the status of the trial court, my lord. The petition, this petition is false, my lord, because the judgment has come, my lord.
Okay, serial number
29,
29. We will call it up. Who is there for the petitioner?
Rajesh Kumar Gupta, my lord. Rakesh Kumar Gupta.
Rakesh. You just wait for a while. Yes, what happened in your case? Yes, please come. Who is there for the stamp reporting? What is your objection? आपका क्या objection है?
को रजिस्ट्रेशन नंबर पर ईयर रिन्यू होता है, तो ये 2021 का रजिस्ट्रेशन नंबर है और फाइलिंग 2023. मैं डिफेक्ट था कि करंट रजिस्ट्रेशन
नहीं. It has not been renewed.
No, my lord, he had applied in 23. The office bearers of clerk associations are also there. He has already applied, and he has also part and parcel of the Lipik Sangh, my lord, the Ryota Lipik Sangh. He is paying his receipt. He has got
No,
the
must be.
receipts. But my lord, in between, for 1 year, my lord, due to corona and his wife had a big tumor, he couldn't get it renewed. So it is his fault, my lord. I agree.
So you have to. We can't do anything.
We, my lord, act on a bona fide belief and trust. I saw the card and he said I have applied.
No.
So
You see, unless is there any provision that if you apply, it will stand automatically renewed? No.
so for example, for 23, no card has been issued, but the stamp report is still allowing. Technically, my lord, in 24 also, for 23 you may put a query to them also. They told me.
In
that-
all the जितने भी आपके clerks association वाले हैं, जिनका renewal नहीं हुआ है, उनका भी आप clearance कर देते हैं?
नहीं, जनरली मैडम ये नवंबर मंथ में प्रोसीडिंग शुरू होता है नेक्स्ट मटेरियल के लिए
हाँ.
रजिस्ट्रेशन.
हाँ.
तो ये जो टाइम होता है नवंबर से लेके जनवरी तक का, इसमें हम लोग ये
थोड़ा relax रहे. लेकिन इन्होंने तो अप्लाई ही नहीं किया.
नहीं, इनका तो 1 साल पुराना है.
नहीं, अभी अप्लाई किए हैं.
अभी अप्लाई किया है तो नहीं होगा. We can't do it.
So my lord, now my lord, he has already applied. It will be, but so far as this defect is
You
concerned,
file a fresh affidavit.
I'll
Rectify this defect.
I'll file.
This is the solution.
Yes, I'll file a fresh affidavit, my lords.
You file a fresh affidavit rectifying this defect.
Yes, of course. So obliged.
And application for the renewal is pending.
Yes,
Why
it is pending.
Who is the president of the association?
जो application दिखाई.
रिन्यूअल के लिए आप लोगों ने अप्लाई किया हुआ है?
जी
अभी तक हुआ नहीं रिन्यूअल?
नहीं, अभी कुछ लॉट आया है वो, लेकिन उसमें से बहुत सारे जो है आया ही नहीं. लोग आधा अधूरा प्रिंट आउट होगा.
तो भाई आप जाके आरजी साहब से मिलिए,
जी
उनसे रिक्वेस्ट करिए कि भाई जो रिन्यूअल का काम ऐसे तो फिर आप लोग की भी तो रोजी रोटी हैम्पर हो जाती है.
वहाँ जाकर बोलते हैं कि वेरीफाई पर्टिकुलर जगह से आता है जो पहले का ही कॉपी किया हुआ, करीब इतना मिसिंग है, और बहुत लोगों का नेम में गलत है, किसी का ईयर गलत है, किसी का नेम गलत है।
They said, my lord, that if an
एक
observation,
हम उनको थोड़ा
an
समझने दीजिए.
observation
They
is
are very
made.
senior persons of the association. They are quite aware of what is happening. We are also aware. तो कुछ लोगों का रिन्यूअल होके नहीं आया है. Is there any reason? तो ये ऐसा रीजन होगा ना कि रिकॉर्ड नहीं मिल रहा है या पता नहीं चल रहा है.
नहीं, रीजन कुछ नहीं है. वहाँ पे जो बनाने वाले हैं, जहाँ जाता है बनने के लिए, उनकी गलती है. और यहाँ से जो ऑफिस मंगाते हैं,
बट कहाँ जाता है बनने के लिए?
शायद ऑफिशियली थ्रू जाता है, ओवर फ्लाई के नीचे कोई
फ्लाईओवर के नीचे.
वेंडर यहाँ से ऑफिशियली जाता है.
आजी साहब को जरा बुलाइए. किनके पास ये पेंडिंग है? आजी साहब के पास पेंडिंग है.
नहीं, आपका ये असिस्टेंट आरजी या
उनका नाम क्या है?
सतीश जी.
सतीश जी बोल के कोई है?
Establishment.
हाँ, तो जरा उनको थोड़ा बुलाइए. ठीक है. कोर्ट से उतरते हैं, थोड़ा आप लोग भी आइए चेंबर में. इसको रिजॉल्व करना बहुत जरूरी है. इसको पेंडिंग नहीं रखना.
If an observation is made, my lord.
नहीं, ऐसा ऑब्जर्वेशन हम जुडिशियल ऑर्डर में नहीं कर सकते, बट वी विल फिगर इट आउट दैट इट
Yes,
इज
yes.
रिजॉल्व
If my lord intervenes, this problem will be sought out for.
तो ये तो जस्ट एडमिनिस्ट्रेटिव ब्यूरोक्रेटिक रीजन. किसको स्टे कर? ऐसा हम लोग नहीं कर सकते. कोई पिटीशन नहीं है, कोई कॉज ऑफ एक्शन नहीं, ऐसा नहीं कर सकते. यू रिमूव द डिफेक्ट बाय फाइलिंग एन फ्रेश एफिडेविट.
I'll be removing. I'm only praying, my lord,
Yes.
that there is some urgency. Therefore, it may be
नो
listed
नो,
on.
यू डू इट. आप जल्दी, जितना जल्दी कर
My lord, on
लीजिए.
Monday itself, I am praying only, my lord, that it may kindly be listed on 20th, because it came only
I
after
can't-
mentioning. My lords, what
You
has
see, I
happened?
can't do anything about it. You can अभी 2:30 हुआ, you file an affidavit today itself and you choose your date. We will fix it. You remove the defects first.
My lord, it will be possible by Monday, because, my lord, I have to
I
call.
do not know what.
I have to call the petitioner, my lord, from Gumla, my lords. So therefore, on Monday, I'll positively remove, and therefore,
Learned
I'm
Counsel for the.
I'm praying, my lord, it may
Please
be
hold
kept
on.
on.
WPS number 7083 of 2023. The Learned Counsel for the petitioner has submitted that the defect in the present case will be removed by. He may be permitted to remove the surviving defect in the present case by filing a fresh affidavit.
By Monday only, my lord. On Monday itself.
He prays that the same would be done by Monday.
My lord.
Let the
Therefore,
defects be removed by Monday. Post this case on Tuesday. Okay,
I
and
will.
ensure that I will not pass any order in a defective petition.
My lords.
In principle, I don't do it.
Yes, my lord. This
So you
problem-
check your records.
Two defects are only.
I
One
will.
is with regard to number of.
उनसे बात करिए, वो आपको बढ़िया समझाइए सर. थोड़ा अपना राइटिंग थोड़ा अच्छा करिए. आप लोग का राइटिंग समझ नहीं आता. टाइप करके क्यों नहीं डिफेक्ट दिखाते? टाइपिंग आता है ना आप लोग को? ऐसे राइटिंग आप लोग का समझ में नहीं आता है.
हम लोग बहुत घबराते हैं मैडम स्टैम्प रिपोर्ट से. स्टैम्प रिपोर्ट so many टैग नहीं है, ये नहीं है, वो नहीं है.
उनका काम है सर. नहीं
ज़्यादा-
करने से भी उन लोगों को शो कॉज हो जाता है.
अब like
आप जल्दी जो है
कोलकाता-
ई फाइलिंग शुरू कर दीजिए. ये सब कहानी खत्म.
कोलकाता इस समय नहीं, आज फाइल करते हैं, कल परसों लिस्ट आ जाता है. वो के टाइम में
देखिए, आप चले जाइए कोलकाता, हम तो नहीं जा पाएंगे.
my lord may go to Delhi.
For orders with defect, item 1,
Outline.
Resolution 29 of 2022.
There are all defective petitions. I'll pass one order. First, tell us, is there any case for IA for ignoring any defect?
Defect serial number 2.
Just a moment, please hold on. ये सब item को अलग कर दीजिए. Serial number 2, then
Serial number 24 Lordship.
24,
Serial 19.
19,
Serial 20 Milord.
20, 18. That is all.
48 लॉर्डशिप, बट आइए नहीं फाइल की हुजूर इग्नोरिंग के लिए.
क्या डिफेक्ट है?
हुजूर इसमें एक लिमिटेशन लगा हुआ है जो कि एप्लीकेबल नहीं है इस केस में. 102 जुवेनाइल जस्टिस एक्ट का हम रिवीजन फाइल किए हुए हैं, जिसमें बोलता है एनी टाइम रिवीजन कैन बी फाइल्ड.
नहीं, आप प्रॉपर पिटीशन फाइल कर दीजिए प्लीज. दैट यू विल हैव टू डू. एनीथिंग, एनी अदर आइटम अपार्ट फ्रॉम, काइंडली नोट डाउन. सीरियल नंबर 2, 18, 19, 20 and 24. In rest of the cases, time till,
My lord, serial number 29, my lord.
don't disturb like this.
19.
Time till 7th of March is granted to remove the surviving defects peremptory. If the defects are removed within time, post these cases on 14th of March 2024. In case the defects are not removed within the stipulated time, office is directed to prepare the
24.
order of dismissal on account of non-compliance of order of this court, and within a period of 3 days, within a period by 12th of March 2024, and we immediately take steps for immediate communication of the order to the learned court.
Yes, my lord.
Yes, which item?
Serial 29, my lord. On behalf of the state committee petition in infructuous, my lord, because the judgment has
Okay,
come.
I will just call 29.
सीरियल 1 में सरेंडर सर्टिफिकेट डिफेक्ट था, लेकिन 498 मीटर में वाइफ भी मेरे ही साथ रहती हैं, इसीलिए 2 वीक का टाइम मांग रही, इसमें कि ज्वाइंट कंप्रोमाइज।
I do not.
अभी उसके पहले भी अगर माने
We do not know. अगर आपको कुछ भी बीच में फाइल करना है, आइए फाइल करना है for ignoring any defect or whatever, you can file it and mention it.
ठीक हो गया।
Mentioning is your right. The case will be listed on the day you want. Please last day तक इसके लिए wait मत करिए.
ठीक हो गया।
पहले सरेंडर करेंगे तो पहले दिन फॉर बेल
We do not know. आप surrender certificate फाइल करेंगे तो आपका ignore.
Serial number 36 paying for withdrawal.
30?
36.
36. What is your name?
Rohit Kumar Gupta.
Rohit Kumar Gupta, under instructions of
Anuj Kumar Trivedi.
Anuj Kumar Trivedi, advocate on record.
Yes.
Seeks permission to withdraw this petition. वही withdrawal वाला order कर दीजिए. Kindly
Sign
put
कर
this.
दीजिए।
This is for serial number 36. Now serial number 29. Who is there? 29. देखिए serial number 29. फाइल कीजिए.
जो इसमें जो इनका प्रे था, एक स्टेट के तरफ से फाइल हुआ था एफएसएल को एग्जीक्यूट कराने के लिए, उस ऑर्डर को चैलेंज किया गया। प्रेजेंट स्टेटस ये है कि इसमें जजमेंट आ गया। 18 मई 2000।
All right. Criminal revision number 603 of 2022. Nobody appears on behalf of the petitioner in spite of repeated calls. The petition has remained defective. The learned counsel appearing on behalf of the state has submitted that the final judgment
in the 18 May 2023
in the present case has been passed on
18 May 2015
18/5/2023
23
during the pendency of the present case by the learned court below, and therefore the present case has become infructuous. Considering the aforesaid submission, this petition is dismissed as infructuous. Kindly quote the prayer. Next. Now serial number 2. Serial number 2. Somebody wanted a separate order.
Item 2.
Yes.
Your Lordship, in the defect number 8,
8.
which is pointed out by the stamp report, Your Lordship, the para 2 is not mentioned the earlier moved, Your Lordship, the BA, but the petition has moved for the bail, Your Lordship. He has not moved the impugn against the impugn order.
No, you have to disclose every case you have moved arising out of the same FIR. Every case, even if you have withdrawn, if it is dismissed for default, the WP criminal, everything is required to be disclosed. So this order will be the same as the other orders. ये 2 कोर्स में include कर लीजिएगा batch में. You just give a case number and then pass a common order in all those cases. चलिए next. 18.
Item 18.
Yes.
There is defect regarding PS case number at opening bar of review order and FIR, which differ number. FIR there is Gamma PS 3 2022 2021 my lord, and in impugned order, my lord, it is gamma PS 172 of 2021, my lord.
GR number is the same.
GR number, my lord, अभी तक पता नहीं है, GR number नहीं है.
Where is it mentioned in the impugned order?
At para 4. After fourth line. Page 24.
PS case number 172 of 2021.
Yes.
And it is actually PS case number
3 of 2021.
3 of 2020.
By reading of the FIR, my lord, it will be clear that they are same.
No, this is required to be rectified.
My lord, we have filed application before the concerned.
We will send this particular order before the learned court below for correction.
Okay.
Okay. What about rest of the defects?
Rest of the defects are have been removed.
Have been removed. The learned counsel for the petitioner has submitted that the only surviving defect is, as pointed out by the office, is that there is a mismatch regarding the first information, regarding the number of first information report and what has been mentioned in the impugned order. The learned counsel submits that as per the FIR, it was GAVA PS case number 3 of 2021 dated 10/1/2021, but in the impugned order it has been mentioned as GAVA PS case number 172 of 2021.
वो actually ST number है, ऊपर में दिखा है ST number 172 of 2021.
That's right. The learned counsel submits that in spite of repeated efforts made before the learned court below, he could not get a rectified copy of the order impugned. Considering the aforesaid submissions, let the impugned order of the present case be sent back to the court concerned for correction. Be immediately sent back to the court concerned for correction. A soft copy of the records of this case be also sent to the court concerned for perusal and comparison. Post this case on 14th March. 14th March. Under appropriated.
Item 20. Tribunal 441 of 120.
On last occasion, 7/12/23, there was order of 2 weeks time was given as preemptory, same to 20.
We will dismiss this.
20.
For to surrender, no?
Yes, ma'am. And last also,
This is 20.
the IA was rejected.
19.
Which is the last order in this case? I had passed the order on the last day, I suppose. Which order are you referring to?
I am referring to order dated by
This has been filed by the convict.
yes, ma'am. Order dated 7/12/23.
7/12/23. Yes. There is no surrender certificate filed. देखिए, criminal revision number 441 of 2022. Nobody appears on behalf of the petitioner. By the order dated 7/12/2023, 2 weeks' time was granted to remove the surviving defects, indicating that in failure the petition shall stand dismissed without further reference to the bench. However, one interlocutory application was filed, being IA number 9832 of 2023, seeking exemption to surrender before the learned court below on ground of age and illness. The same was rejected by the order dated 12/1/2024, which is quoted as under. As per the office note, the surrender certificate has not yet been filed. And today nobody is appearing on behalf of the petitioner. In view of the aforesaid fact that earlier a preemptory order was passed on 7/12/2023, the prayer seeking exemption from surrender was rejected on 12/1/2024, and no surrender certificate having been filed, the petition continues to be defective. The present petition is dismissed on account of non-removal of defect regarding filing of surrender certificate. You need to quote the prayer. Let this order be immediately communicated to the court concerned for needful. Dismissed.
One of the matters is serial number 33. It was different also, but we have had it.
Item 19.
Chief Defect number 6, the name of honorable judge and order dated has to be mentioned below. But the date is there, but the name of the honorable judge is not showing. That defect may be removed.
No, you have to give the date or name of the judge also.
Name is not showing.
Is not showing in the appeal order.
No, online we have checked.
Judge is the judge of the High Court.
Yes, ma'am.
So you file inspection. What's the big deal about it? It should be included in that list of all this. You can do one thing, you can give a slip here also, then you can get the file. Okay. Today you give the slip because your matter is on the board. You may get it by Monday. They'll ensure that you can have a look.
Item 24, Criminal 514 of 2022.
Yes.
So, I will file your lordship under Rule 159 of Jharkhand High Court rules for exemption of 17 lordship.
What is your ground? What is your ground of seeking exemption from surrender?
Because it's a constant statement lordship that annex the document lordship from the Apollo Chennai your lordship, and he is directed to operate for spinal cord lordship, and he is completely bedridden lordship.
These are the documents of 2001.
2023 your lordship.
This is also 2001.
Lordship, Annexure 1, page 9. August 2023. September 2023.
Where is he now? Where is he?
Is directed to for operation or say managing money. He will go to Chennai
Where
for
is
his
he
operation.
as of now?
As present, he is at Devar.
What is the name of the disease he is suffering?
Spinal cord. What is
Where is it mentioned? Nothing has been mentioned in your petition.
Manson also in petition is suffering from the spinal muscular atrophy problem in his spinal cord in para 5. In other cases, also that Honorable Court has passed the order also for exempting the other petitioner also for surrendering or losing.
Who is for the state? Where is the counsel for the state? Are you there? Get a report. Visit him and get a report. Whatever he has stated in his petition, he is bedridden, not able to move, right? He is in absolutely complete bed rest. Get a report.
Concerned police station.
You take the help of the
Concerned police station, my lord.
concerned police station and a doctor from the
And final report, my lord.
yes, civil surgeon or somebody.
My lord.
Civil surgeon would be a much higher person. You take the help of a doctor, government doctor.
My lord.
IA number 11640 of 2023. It is 23 mentioned. The learned counsel for the petitioner submits that this petition has been filed seeking exemption from surrender of the petitioner who has been convicted for offence under section
25 on Arms Act.
25 within bracket 1B bracket close within bracket A of the Arms Act. The learned counsel submits that the petitioner is bedridden, unable to move, and is at Devghar. Counsel for the state is directed to seek instructions and file a counter affidavit to the IA number 11640 of 2023. And for that purpose, the verification by going to the house of the petitioner be made by the concerned police station as well as accompanied with a government doctor to be appointed by the civil surgeon of the district. Let the affidavit be filed
4 weeks.
4 weeks, then he will say that in the meantime he has gone for his treatment, you know.
After 2 weeks, my lord. After 2 weeks.
Pose this case on 29th of February 2024. The affidavit should be filed by 28th.
Right.
The affidavit should accompany the Aadhaar card of the petitioner with his signature and also a photograph. also a current photograph showing his ailment and condition.
Item 48.
Sequence में कॉल करें.
Orders item 85. Erosion 110 of 2022.
Why is it listed for orders?
It's last order maker division numbers. Order dated 8th of February 2024. Passed by your lordship.
Petitioner is absent now. Petitioner is absent now. Criminal revision number 110 of 2022. The order dated that the petitioner was granted provisional bail on 11/10/2022 for a period of 6 months. But thereafter the petitioner did not surrender. The matter was taken up on 8/2/2024 and following order was passed court condition.
Provisional bail for 6 months was granted, coupled with the fact he has to deposit rupees 2,50,000.
That's right, everything is mentioned over.
Yes.
Today when the case is taken up, nobody is appearing on behalf of the petitioner. And surrender certificate has not yet been filed. In view of the aforesaid circumstances, criminal revision number 110 of 2022 is dismissed. You need to quote the pair. Let this order be immediately communicated to the court concerned for the needful and appropriate action.
But action may be given so that impossible steps shall be taken to secure.
Appropriate action we have said.
Item number.
I will close it.
49, item number 49.
आइए dismiss कर दो. Dismiss.
Item number 49, the sole petitioner Mrityunjay Prasad. It has come under the heading for defects for surrender certificate, but he already died.
Which one? Serial
Item
number?
number 49, under the heading for order with defects.
Let it be then dismissed because we do not know.
Therefore,
We don't want to say
on the
anything.
basis of my submission,
No, we can't. You see, then we have to get it verified. We can't record your submission
then I
like
have to
this.
file an
without-
application on it.
You do whatever.
So, item number 33, an exemption petition was filed. 33 for surrender, from surrender.
33 has been called out. This is for 49, no?
Yes. 33. Order
Which
number
case are
33
you-
under the heading for defects. Defects को जो common order जो किया है.
तो इतना सारा उस समय everybody was there. आपको जब मन होगा तब आपके आके कुछ बोलेंगे क्या?
common order हुआ है मुझे भी मालूम.
कैसे नहीं मालूम? रोज होता है. आपके काउंसिल तो यहीं रहते हैं.
I'm very sorry. I could not.
Where is the petition for exemption for surrender?
That is I have filed, that is reflected in the list.
Serial number?
33.
In this case somebody has died.
दूसरा case 49 number.
33.
33. It is a case conviction under section 138 NIM.
You are seeking exemption from surrender.
Yes,
On what ground?
On the ground that he is ill since 2019. I have supported by medical documents, and number one, number two, he also paid rupees, the substantial amount in the appellate court. Conviction under section 138 NIX, fine of rupees 1 lakh and 550 is the principal amount.
Where is he? Where is he as of now?
He is now in Dhanbad.
Bank draft note copy, I have annexed note page 8.
Where is it mentioned? In Dhanbad he is staying. His
Address?
yes.
Yes, madam. Just
Who has filed this petition?
he is not Delipara, Hirapur,
Daughter.
Dhanbad.
The daughter of the petitioner has filed
Doctor,
this
he
petition.
was earlier, he was under treatment.
You see, you have to deposit the entire amount.
Intern, 20% is the, as per the law, my lord,
Which
apparent
aspect?
in order to maintain appeal, that he has paid.
That
he
you
has
have paid, but in order to have an order of
That is substantial amount, although my lord, he is not
Substantial.
liable to pay as per the case.
no, that we will see once he surrenders. Otherwise, you surrender.
Then I have to seek instruction, or otherwise I cannot say out of my own, my lord. If it is adjourned for only Passover day, so that it can be listed, my lord, next week, I can have this instruction. If he is ready to deposit, then he can deposit. Or he will surrender.
What is his age? 49 years. We will conduct a inquiry by the police station
Yes.
as whether he is sick
Yes,
or not.
yes. You lordship must do this.
And
You are
all
under
you
the-
also seek instructions.
I will also seek instructions. If he is ready to deposit the substantial amount or
Not
the entire
substantial.
amount,
You have to deposit the entire amount.
entire amount, my lord, that should not be paid to the other side because
No, it will remain in
fraud
the
has
court.
been committed to
The
him.
moment if you win, it will be released in your favor. If you lose, it will go to the opposite party. Right from the court.
But at the moment, my lord, I am not giving any undertaking.
इसमें लिख दीजिए the learned counsel for the petitioner submits that IA number 8341 of 2022 has been filed seeking exemption from surrender. He has submitted that 20% of the amount was deposited before the appellate court and the petitioner is suffering from serious ailment and is not in a position to move and therefore this petition be allowed. Upon a query of this court, the learned counsel has submitted that he will have to seek instructions as to whether the petitioner is ready to deposit the
Balance amount.
entire amount,
The entire amount.
the balance amount. The learned counsel for the state is कहाँ का है Dhanbad. The
Dhanbad.
same order, from the concerned police station along with the doctor. The same order. They will go to his house and
Yes, yes.
give a report.
Yes.
Okay. Let this matter be posted under the heading for posted on 20. उसमें कौन सा date दिए हैं? 29. On 29th of February 2024, the affidavit of the state be filed by 28th. Who is for the state in this case? Is anybody there? Here also we need a report in this case also. This is serial number बताइए हमको. Serial number 33.
33.
Same order, you get a report.
So far, not item number 53, I do not want to press.
Okay, serial number 53,
It has become infirm.
the learned counsel for the petitioner submits that he does not want to press this petition as it has become infructuous. This
Criminal
petition is
revision
dismissed as not pressed.
912 by 22.
53.
53. Criminal revision 912 by 2022.
912 of
2022.
2022. Kindly quote the prayer and let this order be communicated.
All right.
इसमें सर साइन कर दीजिए.
Okay.
Infructuous orders में है 43 वाला.
It has become infructuous, so I do not want to press.
That's right, no problem.
Withdraw करने से सही करना है.
Dismissed as okay, dismissed as infructuous.
Yes.
Sorry?
Very sorry.
30. What happened in 30? Okay, serial number 30 भी लिख दीजिए. Same order. है ना? Give your appearance, memo of appearance दीजिए and put your signature.
39.
Mr. Sharvendra Kumar. And this one Mr. A.K. Sani. 30.
13. 1 3.
1 3. Arre bhaiya. 1 3 1 3.
13.
You give your memo of appearance with serial number. As no, it is dismissed as infractions. What else?
सीरियल नंबर 72 में जो मेरा नोबडी अपीयर हो गया है.
But I do not know. Did not come.
Item 86, criminal charge 161 of 2022.
What is your ground?
Petitioners are old age persons.
What is the age?
Petitioner number 1 double by 61 years age.
61 years is not old age. No, not even a senior citizen.
Lordship, allegations are under section 323 and 341. It's a compoundable.
So you file a joint compromise petition?
Lordship, that's why
No, you get no for that surrender will not be done.
Lordship, I will file a joint compromise.
No, you get hold of the other side, file a joint compromise petition. We shall see.
Several co-accused were in custody for 1 month and the period has been reduced to period under 1.
You see, this can only be done after you file a surrender certificate.
Lordship, that's only taken for 2 weeks.
I will give you time, but surrender certificate has to be filed. Or in the meantime, you file your joint compromise.
Lordship, that's why I'm asking.
So you get hold of the, you be friendly with the informant. Get hold of the informant.
Saying that 2 weeks to, in the meantime, I file a joint compromise or I will surrender.
I am giving you 2 weeks time preemptory order. In the meantime, if you file a joint compromise petition, you mention it, we will consider it. You are there for the informant?
For the statement.
For the statement. Who is for the informant? Where is the informant staying? Informant is not a party. You just see what have you done. So parties may have to go to jail because of your negligence. What happened to the co-accused? In another case, they filed another case.
In same case, there are 5 co-accused are there. They were after 1 month of custody, period under 1 order.
Oh, appellate order.
No, Lordship, in the High Court.
Where is that order? For this also you'll have to seek instructions, no? Unless you file surrender certificate, we cannot pass such an order on notice.
Only 2 weeks time.
हम लोगों ने कब तक दिया इनको टाइम डिफेक्ट रिमूव करने का?
7th March.
You see, I have given time till 7th of March to remove the defects. And prior to that date, if you are able to file a joint compromise petition, you may file it. And then we will see what is to be done.
Okay.
But this IA has been filed, no? This is pending.
IA has been filed for exemption.
Okay, counsel for the, इसको अलग से order करिए. Counsel for the petitioner prays for 2 weeks time. Right? He submits that in the meantime there is a likelihood of filing of a joint compromise petition. Is that correct?
Yes, sir.
Pose this case on 7th March under the heading for orders.
Okay.
exemption नहीं करेंगे ऐसे.
They have not taken any ground, only just is an old age person, 1% particularly. Exemption also. If they compromise, that can be done. We are not opposed.
लेके आए compromise.
Sorry to interrupt, madam. Serial number 72.
What happened?
Nobody को कटवा दिया.
Nobody तो अब तो यहाँ तो वीडियो रिकॉर्डिंग होता है ना. We cannot change order.
Item 87, Conversion 251 of 2002.
The case has been dismissed. Must have been dismissed. Time हुआ है फिर कुछ नहीं. चलो. Yes.
Lordship, appearing on behalf of informant.
Informant. You have taken instructions?
Yes.
Yes.
I have filed for joint compromise.
It has been filed?
Yes, Your Lordship, it has been filed, but the offence is under section 392, Your Lordship. It is non-conformable, Your Lordship.
इसको हम नहीं compromise. This joint compromise I will not permit.
इसी हाई कोर्ट.
नहीं तो इसी हाई कोर्ट का है. आप हमको लॉ दिखाइए ना. लॉ ऐसे जनरल ऑर्डर से नहीं सुनेंगे. लॉ दिखाइए. Show me some law that 392 can be compromised. Not compromisable. No, so I can't. I will not.
लेकिन हाई कोर्ट को पावर है.
Have you filed surrender certificate?
नहीं, उसमें जॉइंट कंप्रोमाइज हो गया है और एग्जाम्पशन भी फाइल. पेट्रोल पंप डकैती का
Let me just see. कहाँ है order?
पे नहीं, अदर सेक्शन 366 पे है, 376 पे है.
392 में minimum punishment भी है ना? What is the minimum punishment? लाई तो IPC लेकिन minimum punishment है क्या? मिनिमम पनिशमेंट तो नहीं है. You see, after conviction, I will not compound it. After conviction,
7 तारीख को समय की सरेंडर.
ठीक. Then I will reject this.
ये dispose of
Not pressed करते.
better.
Learned counsel for the parties are present. Learned counsel for the petitioner submits that he does not want to press IA number 3731 of 2022. He submits that some time may be granted to file surrender certificate. Time till 4th March?
7th March.
7th March is the date. I'll fix a date on 7th March. 4th March तक और 5th March तक.
5th.
Time till 5th of March 2024 is granted to the petitioners to file surrender certificate in the present case. Post this case on 7th of March. In case the surrender certificate is not filed within the stipulated time, this petition shall stand dismissed without reference to the bench. IA dismissed as not pressed.
Alright.
May I be permitted to mention a matter within the serials?
Sorry?
One case per which
Which one?
69.
Serial number 69.
Because
Mr.
it's
S.
becoming structures.
The counsel for the petitioner, Mr. S.P. Sinha. submits that the present petition has become infructuous and therefore he does not want to press it. Let this petition be dismissed as infructuous, the order be communicated through fax, and prayer be put.
Item 88, Resolution 264 of 2022.
Yes, petitioner.
It's against the conviction. As per the last order, the provisional granted. and 279. The mother of the victim has already received the compensation amount.
So, compensation amount having been received, so what has to do with this
It was
case?
mentioned in the last order.
The provisional bail dated 18/8/22 was extended till the next date. Right? But no next date was fixed.
Only that they undertaking that he will remain present at the final argument at the time of final argument.
No.
Subject to correct.
No, in the meantime, in the facts and circumstances of this case, it is found just and proper to extend the provisional bail granted to the appellant by the order dated 18/8/2022. You have to surrender. Then only this case can be taken upon merits. You need to surrender. What was the period of provisional bail?
Provisional bail was not, there was no mention about the.
Provisional bail has to be an outer date.
Yes, that's what.
What is the period of provisional bail? For 4 months from today. You surrender immediately. I'll give you 2 days time to surrender and file the surrender certificate. Right? You don't need to take instructions.
The instruction based on last case,
No, it is almost, I think there is not many cases left to be taken. We will not permit this.
As a last case, it will be taken up.
So therefore, this is the order I am going to pass. If your senior has to say anything, you can come.
I'm ask the client that.
You don't need to ask the client. That is the majesty of law.
No, that's
that provisional bail has been granted for 4 months.
They have to
Maybe extended without any petition also, I do not know. Right? There was no petition for extension. Now I will not extend it.
Let it be taken up as a last case.
It is the last case only. कितना case बचा? 10 case बाकी. ठीक है, आइए. नहीं आइएगा तो हम discuss करेंगे. You just wait and see. Next.
Item 89. Division 283 of 2022 allows item 98.
3 prayers.
Yes, first
In one case.
Yes, in the both cases, Lord.
Both. There are 2 cases.
Yes. One is that my pray for 3 weeks time, Lord. Second is Lordship.
3 weeks time.
Yes, Lord.
So this is a prayer in the petition.
No, Lordship. This is my prayer, Lord. Just because. And the second is the Lordship in the IA for the amendment, Lordship.
What amendment?
And the fourth.
In revision, what amendment can you?
Lordship, the difficulty is in the year of 2022, Lordship. Judgment has been reserved, Lordship. Before and yes, Lordship. In the सर के बनने से पहले जजमेंट रिजर्व हो चुका था लॉर्डशिप एंड द ईयर ऑफ 2023 लॉर्डशिप stay order has been passed, Lordship. Kindly see the order of 18/7/2023, Lordship.
Of this case?
Yes, Lordship. In the dated 18/7/2023, Lordship. In the judgment has been reserved Lordship 18/7/2022 Lordship.
Lordship, what happened was that during the arguments, no stay order was passed in this matter.
But judgment has been
Thereafter-
reserved.
Yeah, judgment was reserved, Your Lordship, and
And
thereafter.
after
No,
one
where
year-
is the order reserving the judgment?
In the 18/7/2023 Lordship.
No,
18/7/23
Lordship. Yes, Lordship.
22.
Yes, Lordship.
18/7/22. Why the order passed in criminal revision number 285?
Yes, Lordship.
That is a connected record.
Yes, there is a second
Where is
case.
that? You don't even put a photocopy.
Yes,
Both
both
cases
the
are
cases Lordship.
tagged together, you know.
18/7/22 भाई फोटोकॉपी नहीं लगाते ऑर्डर का कैसे चलेगा? Then what happened? How is it listed?
This is our difficulty, Lordship. This is the already date has been changed and the name is there appearing in this so and so. So I am praying for this.
No, this is order is reserved.
Yes, Lordship.
18/7/22.
Yes, Lordship. In the 18/7/2023, Lordship.
Then 18/7/23, what order was passed?
And then still further order, Lordship. Order has been passed. In the
Nobody pointed out that the order was reserved.
Lordship, this difficulty we have pointed to 2 times. We are mentioning this case, Lordship. We give the judgment, Lordship. And after 1 year, Lordship.
Virtually, apparently, the honorable judge has asked for fresh hearing.
Yes, Lordship.
So we start.
But difficulty is there, Lordship. 3 weeks.
Then
time.
how this matter has come up before me?
The
There is an
IA is
assignment.
pending. IA is pending. 2 IA is pending, Lordship.
22. Not an assigned matter.
Oh, 22, not an assigned matter.
That's the reason. The 2 IA is pending.
IA for?
IA for amendment, Lordship.
What
During
amendment?
pendency of the this petition, Lordship, charge has been framed against the petitioner, Lordship. That has been brought up before, Lordship. We have filed the amendment petition.
When was it? When was the charge framed?
6/6/2022, Lordship.
And when was the petition filed?
Petition is, Lordship.
26.
In the 22 in the file.
You filed a separate revision petition for that. Because you see, the charge, the framing of charge, that itself, each ingredients of each of the section is to be seen. This charge has a different contour altogether. So,
It's my prayer, Lordship.
for that IA, for that you have to file a separate petition. We will not entertain it here.
Only 1 week time, Lordship. One person is running out of Mumbai and other is second is Lucknow, Lordship. We communicate. So 1 week time.
Alright. The other part is the other IA?
One IA only.
Only
Both
one
cases.
IA in both the cases.
Only one. Both is the amendment petition. Lordship. We filed the IA for the amendment.
So IA you don't press then?
Lordship, only for not today. Today.
Not today for not pressing the IA?
No, only for not today. And one.
Not today means Monday.
Yes.
The learned counsel for the parties are present. The counsel for the petitioner in both the cases has submitted that the order was reserved by a coordinate bench of this court on 10/5/2020 on on 18/7/2022 and thereafter by order dated 18/7/2023 the matter it has been recorded that these two revision petitions are required to be heard in the light of a number of judgments referred to in the order. And by the said order and further proceedings in miscellaneous criminal application number 160 of 2022 and miscellaneous criminal application number 313 of 2022 in connection with RC 09 within bracket A bracket close slash 1997 dash D has been stayed. 97 का case?
Yes. Just 3 or 4 time litigation in the
अब नहीं रहेगा pending ये case. You just prepare yourself.
I'm praying for all of you engaging.
The learned counsel has submitted that during the pendency of this case, the charge has been framed. And for this, interlocutory applications has been filed seeking amendment of the main petition. Are you opposing or supporting?
Yes, Your Lordship will have to file a reply to this
The learned
because
counsel for the opposite party has opposed the prayer. She submits that a reply may be filed. She submits that a reply is required to be filed to the interlocutory application. However, this court is of the considered view that the scope of consideration in the case of rejection of discharge petition and that of framing of charge under various sections by a different order is not one and the same, and therefore this court is prima facie not inclined to allow the interlocutory applications. Upon this, the counsel for the petitioner seeks 1 day accommodation. Post this case on Monday under the heading for orders to be taken up at first case at 10:30 in the morning.
1 week prayer on it. Just because you one is
Don't detract from your words.
no, I'm this thing. Only for
Should
prayer.
I replay the video?
No. See, but I just confused.
You see,
कि
I
one
have
week
a very
है,
big support.
Yes. But it's my prayer. Also, 1 day is the very.
1 day is,
Today-
you have got 2 days.
Today is Saturday, Lord. जो so that I pray. Today is
जो
Saturday.
accused
one day
होता है
is
ना, वो
already
संडे को सोता नहीं है.
gone.
I think 91, Criminal Division 298 of 2022.
I'm so happy with this online transmission, I just can't. At least the councils are sticking to whatever they are saying.
It's my prayer, Lord.
I know.
I pray this week.
On Monday, 10:30, first case. Yes.
Complainant has preferred this revision lawsuit, where the opposite party number 2, that is respondent 2, has been acquitted of the charge under 138(9).
Who is for the OP number 2? It is for admission.
Yes, sir. Notice and not
What is the ground for acquittal?
premature complaint, Your Lordship. Considering that.
What is the timeline?
30 days after the service of the legal notice.
Let us see the dates.
Yes, page number 33 of the impugn judgment, Your Lordship. 15/5/2017 is the impugn check, Your Lordship. And legal notice was sent on 30/5/2017.
What is the mode?
Ordinary process. Registered cover.
Okay. When was it filed? 36. Perfect order. Has it been decided on merits? 15/5 check issued, 18/5 check bounced, 35 legal notice dispatched through registered cover, 36 you filed the complaint case. No response was received?
What is the presumption that once the under General Clauses Act also given
After 1 month.
1 month, 27 days.
So? There is we have passed certain judgments wherein we say that if in a case of premature complaint, The right to file a fresh complaint will
complaint.
there.
With
But
the
you are
direction-
not arguing that.
The same direction was given by the appeal court, appellate court.
Where is that direction? Where is that direction?
Uh,
To file a fresh complaint.
Yes,
It is there. No case is made out. Why do you want to harass anybody? What are your grounds? Is this finding incorrect?
Pre-measure 35 2017 also. That is the service of legal notice.
No, that is not. That is a dispatch of legal
Dispatch.
notice. Dispatch of legal notice. Presumption would be after how many days?
To start from the point of the dispatch.
Dispatch. How many days?
30 days.
30 days. And when did the 30 days expire?
On, because the May is 31st month, 31st day, 31 days.
Okay.
29 expired. On the,
If 30 is excluded,
it is filed on the threshold date, that is 30 of 5, 2017.
when was the case filed? Date of filing? 36.
Yes, 36 2027. 2017.
You see, after service of notice, you have to give him 15 days, and then only the complaint case can be filed.
Yes,
So that 15 days hiatus is missing?
it is 30 days, you are saying.
No. After that, you have to give him some time to
15 days.
15 days time. No, I think 15 days
15
is there.
days.
Then that 15 days thereafter only you can file the case.
After the dishonor of the check, 15 days, within that time.
After the dishonor of the check, you have issued the notice. Right?
Yes, sir.
And after issuance of notice, you have to wait for 30 days to get the notice served. Right? So notice was served on 36/2017. Let us assume 29/6/2017.
2017 is the date of filing complaint.
You assume that the notice was served, 30 days expired on 29/6/2017. Right?
Yes.
Then also you have to, after the service of notice,
30 days.
you have to wait 15 days or 30 days for him. That is the time for making payment.
Making payment.
Yes. That time has not been given.
I will prepare on that point with the
Prepare.
judgment, sir, lordship, but once the notice.
Monday you prepare?
Notice, if the required notice may.
No notice.
Then I
We
will
don't
prepare.
harass people like this.
Then on Monday. And one more thing, your lordship, office had pointed out the defect.
It's a defective petition.
Yes, sir. This is against acquittal, and as per the new Mallikarjun Kodagili judgment, that appeal for specially that has to be filed
No
by
criminal
the
division, no. Is it so?
But office had pointed, that's why I had mentioned it before the lordship.
No, there is nothing. Revision is being filed against acquittal also. Not maintainable by the order dated.
One order was passed by 1281 of 2016.
Where is that order?
I have not order with me right now. Let it be kept on Monday. I will make myself prepare about that.
I think all these cases revision has been filed.
This latest judgment has been passed, Your Lordship, that victim can file a specific.
No, not in a complaint case. I think not in NIR cases. Revision is being filed against order of reversal. State is not there. Yes. Revision is being filed against the order of reversal passed by the learned appellate court.
Concerning advocate Vandana Bharti.
Where is she?
Let it be kept on Monday, Lordship.
It will come on next Thursday.
Next Thursday. Must be.
At the request of the counsel for the petitioner, post this case on next Thursday. जरा ये judgment जरा देखिए कौन सा है.
Mallikarjun Kodagli of 2022.
I know it is there, but I don't remember the exact content of the judgment.
Much of it.
Item 92, Criminal Division 308 of 2022.
Your Lordship, an IA has been filed for exemption.
Seeking exemption on what ground?
Your Lordship, the case was registered under Section 3 of Public Damage to Public Property Act, Your Lordship. And SI for 2 years was and ₹500 fine and ₹5,000 was directed was told to pay to the government of Jharkhand as compensation amount, Your Lordship. And in the IA we have clearly stated that he is ready to pay the amount of compensation, Your Lordship.
That cannot be a ground for refusing to for not surrendering. देखिए. देखिए criminal revision number 308 of 2022 with IA number 3333 of 2022. The learned counsel for the petitioner submits that the petitioner has been convicted in connection with GR number 77 of 2016 within bracket TR number 184 of 2017 bracket close arising out of Kolibera PS case number 12 of 2016 for offence under section 3 of the Prevention of Damage to Public Property Act 1984. He submits that the petitioner has been sentenced to undergo simple imprisonment for a period of 2 years with a fine of ₹500 and has also been directed to deposit ₹5,000 in the account of the government of Jharkhand as compensation under section 357 of CRTC. The learned counsel submits that since the petitioner has stated that the petitioner is ready to deposit the fine amount and therefore the petitioner be exempted from surrendering the and therefore this petition has been filed seeking exemption from surrender. After going through the petition being IA number 3333 of 2022, this court is of the considered view that merely because the petitioner is ready to deposit the compensation amount, the same by itself cannot be a ground to exempt the petitioner from surrendering before the learned court below. Accordingly, IA number 3333 of 2022 is hereby rejected. This court finds that by the order dated 5/9/2023, the counsel for the petitioner had himself prayed and was given 4 weeks time to surrender before the learned court below and file surrender certificate. The interlocutory petition having been rejected, the petitioner is directed to surrender before the learned court below and file a surrender certificate by 29th of February 2024, failing which this petition shall stand rejected without further reference to the bench. If the surrender certificate is filed within the stipulated time, post this case on 7th of March.
For this team.
Item 93, Criminal Division 311 of 2022.
Who is for the petitioner? Where is the affidavit regarding death? इसका कोई रिपोर्ट आना था ना, रिपोर्ट नहीं आया. Has not been filed. Nobody appears for the petitioner. Pose this case on seventh of March. Next. It is for fresh file?
No,
Admission.
orders.
Orders.
Item 94, Criminal Division 326 of 2022.
Lordship, an IE has been filed for condonation of delay, Your Lordship, of 8 days, Your Lordship.
How much is the delay?
8 days, Your Lordship.
Rest of the defects have been removed?
Yes, Your Lordship. That expired on 28/3 and it was filed after 8 days delay, Your Lordship.
This is maintenance.
Yes, Your Lordship.
Criminal revision number 326 of 2022 with IA number 10281 of 2022. Issue notice to the opposite party number 2 in both the main petition and the interlocutory application for which requisites be filed. By Monday, will you do it? By Monday? Office is directed to call for just 4,000 rupees.
Yes, Your Lordship.
You are against that also.
The client instructs, Your Lordship, we have to do that.
That's any special ground?
No, Your Lordship.
She is self-employed.
No, Your Lordship, he is a poor laborer working in a garage, Your Lordship.
Okay. All right. Pose this case on seventh of March 2024.
Your Lordship, the requisites may be filed.
Sorry?
Requisites may be filed.
By Monday?
Your Lordship, can it be Wednesday?
Okay, by Wednesday. Under speed post as well as ordinary process.
Item 95, Criminal Division 379 of 2002.
Petitioner?
Yes, the maintenance of limitation petition is also filed.
Limitation
71
petition has been filed.
Yes.
Notice has gone.
No, notice has not.
How much is the delay?
71 days, Lordship.
How much is the maintenance amount fixed?
6,000 and 2,000. Total 8,000.
What is the ground of challenge?
Challenge, Lordship, he has not produced, he was debarred from producing the evidence first, and his salary was counted on the regular basis employee, but he is a contract employee in the electricity department, earns 8,000 per month.
There is no merit in the case.
Yes, Lordship.
He was not allowed to give evidence.
He was not allowed to give one date. He was one date absent, and he was not allowed to give the evidence.
But 6,000, 2,000 is such a meager amount.
Certainly, Lordship, but income of the petitioner is
How much?
also
According to
8,000. Contract employee. Let Lordship.
Same order notice कर दीजिए.
One.
By Wednesday you file the notices.
Item 97, criminal charge 1362 of 2022.
Yes, petitioner.
There is a limitation that has to be responded by.
Lordship, Arguing Counsel is busy in his marriage. His marriage is scheduled on 18th of this month. He's out of station. We'll file our counter affidavit within a week's time. It has already been prepared. Seeking our judgment, Lordship.
You have for OP number 2.
Lordship.
Let us see what is the order. Delay condoned. You just see the order.
Lord,
Argue the case on merits.
Lord, today I am praying for time, Lord. Since Lord, in fact, Lord, in my file, Lord, all documents are there, but Lord,
Only 6,000 rupees.
वो हम ex party judgment है, क्योंकि
So,
ex party
you
has
might not have appeared.
no opportunity of hearing.
You might not have appeared.
So
They will not send you invitation
हमको
cards.
कुछ अवसर नहीं मिला, तो
What अवसर नहीं मिला?
हमको ना कोई प्लीडिंग ही नहीं है, तो उसमें हम क्या बोल सकते हैं?
आप क्या करते हैं बताइए?
हम तो बेरोजगार हैं,
बेरोजगार।
इंजीनियरिंग पास हैं, बट कुछ
Even if you are unemployed, 6,000 otherwise also you have to pay. You just tell us what is the minimum wages of Jharkhand. Are you crippled, disabled, bedridden?
अभी तो 200 के आसपास होगा, लेकिन इसको अगर मेरे
200-500 रुपए है. Do you have any idea?
लेकिन अब तो उस लायक भी नहीं है, मिनिमम वेज भी नहीं कमा पाता है, इंजीनियरिंग पास करके बेरोजगार हूँ।
इंजीनियरिंग पास करके बेरोजगार बन गए हैं, नहीं करते तो कम से कम मजदूरी करते.
Anyway, Lord, but today I am praying as because since in my file, Lord, pleading are not there, Lord. Some Lord, it was misplaced from my file. So anyway, any other date it may be.
There is no merit, even if it is ex parte.
Ex parte,
There is no merit.
The honorable family court has.
Even if we accept your best case, that you are unemployed.
और इम्पोगन ऑर्डर में होल्ड किया गया है, हमारा इनकम 25,000 एसेस किया गया है विदाउट एनी बेसिस, ओनली ऑन द बेसिस ऑफ प्रिजम्पशन.
Notice was not served on you.
No, Lord. It was for Lord. In the order sheet it come that the notice was served to the brother, although at the relevant point of time brother was residing in different place. That is why we could Lord, during the pendency of COVID-19, notice the order was passed.
When do you want?
Lordship, we will file a counter affidavit within a week's time.
To the limitation. You get prepared for the final order.
Lordship, my senior counsel is busy in his marriage. His marriage is scheduled on 18th of this month. Seeking argument for this date.
So when should I post it? You just choose a date for yourself.
Lordship, in the first week of March, it will be comfortable for us, Lordship.
Learned counsel for the parties are present. The learned counsel for the opposite parties. Number 2 and 3.
Lordship.
2 and 3 seeks adjournment on ground of the personal difficulty of the arguing counsel. He submits that the matter be posted in the month of March. Post on 1st of March. The parties to get ready on the interlocutory application as well as on the merits of the case. Till the next.
Item 98, criminal charge 1367 of 2022.
Yes, petitioner.
Yes, Lord. The petitioner is aggrieved by his conviction under section 138 of NIA.
Surrender certificate filed.
Surrender certificate. Sir, jail, wakalatnama from jail has already been brought on record.
I have already filed suspension of sentence. IA number.
Wakalatnama from jail. Where is that? Where is that Wakalatnama from jail?
I have filed it.
When? When did you file it? When did you file your Wakalatnama from jail?
IA number 11591 के साथ फाइल की हूँ.
जरा बताइए, इनको जरा रिकॉर्ड दिखाइए. जेल से वकालतनामा ये बोलते हैं फाइल की. दिखाइए. Let us have a look at it. जितना भी क्रिमिनल रिविजन है ना, समीर जी, आप लोग का ड्यूटी है. कोई भी कन्विक्ट है, ऑफिस पॉइंट आउट नहीं करता है डिफेक्ट. You have to ensure that the surrender certificate is there or the wakalatnama has been filed from jail.
Surrender certificate is annexed along with IA. Certified copy of order is there.
IA was for what purpose?
IA for suspension of sentence along with surrender certificate. There are two interlocutory applications.
Who is for the opposite party?
Although notice was issued in the year 2022, on 2nd of February 2023, but no one has put his appearance, and by last order on 25th of January 2024, the Honorable Court has pleased to hold that the service to OP number 2 is validly served by the order dated 25th of January. Surrender certificate is at page 34E, page 13 and 14.
That's right.
That's
The notice has been served.
Notice has validly been served. It has come by the order dated 25th of January 2024.
By the father of opposite party number 2.
Lordship may kindly peruse to order dated 25th of January 2024. Passed by the Honorable.
So you want to argue the case?
Lordship. In this matter, Lordship, the complainant is the dealer of tractor who has not delivered the trolley to the present petitioner, who is the purchaser of tractor and trolley. Trolley has never been given to the petitioner, therefore 85,000 rupees has also not been given to the by the petitioner to the complainant. In this matter, Lordship, after expiry of period of notice, the check has been, some dates are very important.
Give me the dates.
Yes, Lordship. Check deposited on 21st of March 2015.
Check date. Check number. Check date.
Check date is 15th of 15th of January 2015.
15/1/2015.
चेक नंबर
बाउंस डाउन.
हाँ, बाउंस हुआ ये 21 मार्च 2015 को.
Bounced.
हाँ,
Notice.
लीगल नोटिस was sent on 6th of April 2015.
Legal notice.
Yes.
Okay.
Thereafter, present case was filed. Complaint case was filed on 21st of May 2015. 21/5/2015.
Yes.
Yes, sir. As per section 138 of NI Act, the notice a complaint must be filed just after 45 days, Lordship, because within 15 days notice has to go, thereafter 1 month, and after expiry of 45 days, the complainant must have to file complaint. But it was never done. As per from provisional of page 37, Lordship, it may appear.
This is the date of legal notice, 6/4/2015.
Yes, Lordship.
Through what mode it was sent?
It was sent through registered post, but delivery report is not brought on record.
Okay. Registered with AD.
Registered with AD.
With AD. Now it will get served when? 3/5. 3/5/15 it will get served.
As per complainant.
Deemed service.
Service report is not there.
Okay, it will not be there.
Yes.
But deemed service will be on 3/5
Yes, Lord.
plus 15 days.
Plus 15
How much? 18/5.
18/5. On
Right?
21st May 2015, the present complaint case was filed without condemnation.
No condonation of delay is required. After that date, after 15 days, right? He has to file the complaint within 1 month. 1 month, or I think 15 days. Earlier it was 15 days, now it is 1 month. It is within time.
As per section 138
Kindly read section 138.
Lords.
Yes.
I am placing provided because 3 conditions are required to be fulfilled by the complainant. Provided that nothing contains in this section shall apply unless the check has been presented to the bank within a period of 6 months. Now 3 months will be the time.
Okay.
From the date on which it is drawn or within the period of its validity, whichever is earlier.
That's no problem about
No problem.
Okay.
The payee or holder of in due course of the check, as the case may be, makes a demand for the payment of said amount of money by giving a notice in writing to the drawer of the check within 30 days.
Complied.
Okay,
complied. Then?
Of the receipt of information.
Okay.
Clause number C. The drawer of such check fails to make the payment of said amount of money to the payee, or as the case may be to the holder in due course of check within 30 days of the receipt of said notice. 15 days of the receipt of said notice.
Okay. So 1 month from the date of issuance of notice, right?
Lords.
And 15 days from the date of receipt of the notice.
Delivery report is not there.
Need not be there. There is the presumption that it will deemed to be delivered after expiry of 30 days, 1 month. It is absolutely within time. That is the only point.
The second point is that the prosecution complainant has proved 3 witnesses, including himself, and defense has also produced 3 witnesses, including the present petitioner himself. But evidence of defense has never been considered by the trial court.
So altogether 3 witnesses were produced from the defense. Who
And
were the
3
witnesses? And where is it mentioned?
Yes, Lord. Page 26, which is the part of judgment, internal page 4, page 26.
Yes.
Paragraph 8. The defense in its turn has examined altogether 3 witnesses. They have not been taken care of.
So where is the evidence?
Yes, Lord. Evidence of DW1 at paragraph 14, 15 and 16.
So blank checks was given.
Yes, Lord.
So
trolley has never.
The signature was there on the check.
Yes.
Your signature is disputed.
Earlier, in the defense evidence of complainant accused present petitioner who has been examined at defense witness number 3 has denied his signature but admitted that he has handed over his entire checkbook to the complainant who is the borrower. But second point is that the petitioner has denied the statement of complainant that he has taken any amount from him. The case of the complainant is that he has deposited rupees 85,000 in the joint account of present petitioner and his wife, but no such evidence has ever been produced before the trial court by the complainant. Because the complainant has produced the exhibits which are at page 26.
It was a case of friendly loan.
Friendly loan. The complainant himself and his witnesses.
He returned 15,000 and 70,000 remained due.
Remained due, and he has given 2 checks. One check has been produced, and
your case is that you had issued a security check.
My case is also that I have issued security check, and case of the complainant.
Once you say that you had issued security check,
Lord.
issuance of check is not in dispute.
Yes, Lord. Because security check is also issued in discharge of liability.
Not necessarily, but at least issuance of check is not in dispute.
Yes, Lord.
Whether it was in discharge of liability or there was any liability or not is a separate thing.
But complainant case is admittedly is that friendly loan was given, and discharge of that friendly loan I have returned 15,000 and I have given 2 checks to him, which has been, one check has duly been in cash produced before the bank, which has returned unpaid as per complainant case.
That's all.
Yes, Lord. Therefore, I am placing that interlocutory application number 11296 of 2022 filed for exemption may be withdrawn, and I am placing.
You are not surrendered.
No, I have now.
Yes.
Now I have surrendered, but it is required to be withdrawn because earlier I have filed one exemption, exemption case.
That is IA number?
IA number 11296.
11296
of 2022.
इसको लिखिए IA number 11296 of 2022. Counsel for the petitioner has submitted that since a surrender certificate has been filed, therefore this interlocutory application has become infructuous.
Yes.
Considering therefore his submission, IA number, and he therefore does not want to press it. IA number such and such is dismissed as not pressed. Okay,
and I am placing IA number 11591 of 2023.
What is it?
For suspension of sentence.
No, I am hearing it finally. What do you mean suspension? करता सुन लिए पूरा और क्या सुनना अब क्या सस्पेंशन
सस्पेंशन
सुन लिया आपका केस पूरा रिवीजन में कहाँ लिखा है कि एडमिट करके होगा
LCR has not been called for, therefore
what LCR
trial court evidence of both the parties.
तो आप इतना देर से क्यों बहस कर रहे हैं
नहीं तो हम
should have immediately asked.
I am placing that Lordship is prima facie considering the interlocutory application for suspension of sentence. Therefore, I am placing my case. हम कैसे कर दें कि हुजूर को क्या ऑर्डर करना है?
You never said that you are pressing your application for suspension of sentence. एक हफ्ता से ज़्यादा नहीं सस्पेंड होगा हमने LCR तुरंत मंगाते हैं।
नहीं तो एक
अब सुन लिए हम आपका बहुत केस।
ठीक है तो सस्पेंशन तो किया जाए क्योंकि 12 से कस्टडी में है।
आइए नंबर कौन सा
11591 2023
See, don't play hide and seek with this court, okay? If you want to press suspension of sentence, you have to immediately say that you are pressing suspension of sentence.
Just by
after arguing the
just by opening
you
my
never even pointed out that you are pressing the suspension of sentence, isn't it?
The surrender certificate is the part of my interlocutory application which says that IA for suspension of sentence, Lordship.
So prima facie you do not have a case. But still suspension of sentence I will grant you because LCR is required to be called for. But you deposit the amount. Subject to deposit. They will not withdraw that. Subject to deposit.
लुक स्टडी में वो जो अनएम्प्लॉयड यूथ था उसको एविडेंस में आएगा ये सब अनएम्प्लॉयड यूथ है अभी भी अगर प्लेस करें हम अनएम्प्लॉयड हमारे पास तो सब रिकॉर्ड है तो अनएम्प्लॉयड यूथ था उसको लोन दे दिया ट्रैक्टर से कमा करके भरने के लिए और ट्रॉली दिया ही नहीं यही हमारा केस है
IA number 11591 of 2023 the counsel for the petitioner has submitted that the sentence be suspended. The petitioner is in custody since
12th of December
12/12/2023. He submits that the LCR may be called for. The learned counsel on the merits of the case has submitted that the notice was not served upon the accused and the timeline as prescribed under the Negotiable Instruments Act was not satisfied and the complaint case was premature. On the complaint case was delayed
without limitation application
without filing any petition for condonation of delay. The learned counsel has also submitted that defense witnesses were examined before the learned court below, but before the learned court, but the trial court as well as the appellate court has not appreciated the defense version of the petitioner. After hearing the learned counsel for the petitioner and considering the facts and circumstances of this case, this court is of the view that lower court records would be required for proper adjudication of the present case. Office is directed to call for the lower court records. In the meantime, the IA number
115 नहीं हो
in the meantime, the sentence imposed upon the petitioner is suspended and the petitioner subject to furnishing a bail bond of 2 sureties of 20,000 each. The bailer should be close relative of the petitioner. बाकी usual condition, Aadhaar and all.
एक क्लोज रिलेटिव कर दिया जाए
One close relative of the petitioner.
नहीं मिलता है बेलर रिलेशन
That वो लोग और भागते हैं. Let this order be communicated through fax. Post this case under the heading for final disposal on
आफ्टर होली कर दिया जाए
हमको तो कल का नहीं पता. आप होली की बात.
नहीं आफ्टर होली इसलिए कह रहे हैं कि थोड़ा निकल जाए तो रेस्ट कर ले.
On 20th of March 2024. 20 तारीख would be Wednesday, 21st March.
Again, when the notice may be sent to speed post.
Okay.
APP may be directed to serve notice through police station.
Okay. The office is directed to the counsel for the state is directed to serve the notice. let the notice be issued, let fresh notice be issued to opposite party number 2 through the concerned police station, for which requisites be filed by Wednesday.
हाँ फाइल कर देते कस्टडी में
आपको खुद ही करना
नहीं वो
by
ये
Wednesday you file the requisite. They will
वो
take
हम डिनाई
steps.
नहीं कर रहे हैं. आई एम जस्ट सबमिटिंग वन मोर थिंग कि थ्रू पुलिस स्टेशन जो भी अभी नोटिस हो रहा है अभी दूसरे केसेस में भी हो रहा है,
आ जाएगा सब
वो
लोग
पुलिस स्टेशन डायरेक्ट कम्युनिकेट कर देता है एक चिट्ठी लिख करके.
नहीं ऐसे नहीं होता है.
और
ठीक है, नहीं रिक्विजिट आप फाइल कर दीजिए. ठीक है. And the Council for the State is directed to seek instructions from the concerned police station and file affidavit regarding service of notice upon respondent number
Ordinary process
on opposite party number 2. Requisites by Wednesday file कर दीजिए. Affidavit to be filed. Ordinary process नहीं होता है कुछ भी. ये पुलिस स्टेशन से यहीं से भेज देते हैं. आप यहाँ फाइल करेंगे ना रिक्विजिट, कोर्ट से चला.
हाँ तो कोर्ट में वही कह रहे हैं कि बाय बोथ प्रोसेस ऐसे होगा और ऐसे
कोई प्रोसेस नहीं है पुलिस स्टेशन
मतलब वन मोड ऑफ सर्विस है कि दो
ओनली थ्रू पुलिस स्टेशन. We will not burden you more.
नहीं यही मेरा सबमिशन
by 7th of March you file your affidavit by 7th of March.
ऑर्डिनरी प्रोसेस हमको फाइल करना है कोर्ट में नहीं, ये हम कह रहे हैं.
हाँ आपको तो ऑर्डिनरी प्रोसेस ही
वो क्लियर कर दिया जाए. तो ऑफिस बाद में कहता है कि दोनों प्रोसेस में फाइल
नहीं
बस ऑर्डिनरी प्रोसेस.
For hearing item 99, criminal version 17 or 2022.
We are extremely sorry to inform the court that yesterday the petitioner had wrongly given instructions to us that he is wife is residing with him for since 2 years.
But they were pretty much sure after making that submission.
The husband was there. You
Yes,
say that the husband is there in the court.
And today he is not here.
Today is not there.
Today is not here.
And that lady is here. So you have made wrong submissions.
We have not made.
This is the bad conduct.
That's right.
Petitioner.
So your petitioner should suffer, isn't it?
Therefore, we are sorry, very sorry.
No, just sorry will not suffice.
They said
You have
they
to pay
done
some
the
cost also.
amicably they have settled the matter.
Where is that order?
also
Yesterday did we pass any order to that effect?
Only simply only
We simply
simple as
adjourn. That is why we should record all these wrong submissions made by the councils under the instructions of their advocate. Now it is for final hearing. You argue the case.
Yes,
You
let it be
argue.
heard on my merits.
You argue. Come on. चलिए argue करिए आप अपना case.
Informant has filed complaint petition for the allegation under section.
Are you ready? Yes.
For the allegation under section 325 IPC and 498A.
You have filed your surrender certificate. Oh, this is.
The petitioner.
You are on bail.
Yes, sir.
Petitioner has been granted bail by this court.
Yes, sir.
Oh, 98. Section 4, you have been convicted.
I am convicted under section 498 AIPC for 2 years.
What is your ground? You tell us what is your ground. You are in revision.
Lord, sir. The ground is that there is no. The allegation is that the petitioner has demanded 10,000 rupees cash and one color TV, and that was not fulfilled by the informant and her father. That is, and the allegation that due to that the petitioner have used one stick lakdi, and for that his hand was fractured.
Whose hand? Ladies.
Her wife, his wife. And he got treatment at RIMS and therefore returned, and once she came at home, at her matrimonial house, at a Mackay house. In the case, let's say, to petitioner was remained in custody for.
Custody is irrelevant.
1 year.
We'll see custody later. What
Yes.
is the case on merits? What is the perversity in the orders?
In the case that the lower court has not taken into consideration that when the petitioner was demanded dowry amount or cash amount or TV amount, it was not reflected in the depositions. And second,
The date of occurrence is not there. But the date of injury is there.
Date of injury is not. मतलब she
Date of injury is also not there.
she gone to RIMS and there the petitioner himself has taken to RIMS. And on returning from this after plaster, she gone to her. वो अपने पिता के हस्बैंड के साथ जो विक्टिम है वो रिम्स गई. रिम्स में उसका इलाज हुआ. उसके बाद वो अपने पति के साथ लौट रही थी तो रास्ते में उसके पिता मिल गए और उन पिता के साथ अपने मैके आ गई. दूसरा ये इसमें एग्जिबिट 1 हुआ जिसमें कि जो ये इंफॉर्मेंट है वो अपने पति से तलाक खुला ले लेती है. एग्जिबिट 1 और ये भी बोलती हैं कि यदि हमें इनके ससुराल में 2-3 डिसमिल यदि हमें चंदवे में 2-3 डिसमिल जमीन ये हमें दे देते हैं और 1.5 लाख रुपया 1 से 1.5 लाख रुपया दे देते हैं तो मैं यह केस उठा लूंगी. ये इनके डिपोजिशन में भी आया है इंफॉर्मेंट के और इनके फादर के जो CW2 है. CW1 इंफॉर्मेंट CW2 ये इनके डिपोजिशन में भी आया है कि ये हमें 2-3 डिसमिल जमीन वहां दे दें तो मैं ये केस उठा लूंगी. ये डिपोजिशन में है तो कोर्ट बोलेंगे तो मैं अभी स्टडी कर बता दूंगा. तो कोई रेलिवेंट डेट नहीं है इसमें मांगने का. कोई ना हमने कब मांगा ये वो बोल रहे हैं. और फिर उसके बाद ये 10,000 रुपया कैश ये कलर टीवी मांगे और नहीं आया है.
What is the date of marriage?
Date of marriage
3/12/2000.
13/12/2000 अंडर मुस्लिम लॉ. और देर आफ्टर उसके बाद ये बोलते हैं कि इनके 5 बच्चे भी हुए. तलाक खुला लेने के बाद भी ये अपने
आज तो आपके ऊपर कॉस्ट तो हम जरूर करेंगे क्योंकि दिस ऑर्डर इज देयर, अपलोड भी हो चुका है.
व्हाट्सएप कल हमको
नहीं कॉस्ट वो उन्हीं पर करेंगे.
देखो बोले हमको कोई हम सबमिशन कर दिए.
कोई बात
कि हम साथ
डिसऑनेस्ट आदमी जो है पहले घर वालों को परेशान करता है, फिर वकीलों को परेशान करता है, उसके बाद कोर्ट को भी परेशान करता है. कोर्ट में बैठ के झूठ बोलते हैं.
तो जो बोले वही हम सब
ये वो ठीक है.
तो कल आए थे कोर्ट में अपीयर भी बैठे थे. जॉइंट कॉम्प्रोमाइज आज हम दोनों को लाए थे. जॉइंट कॉम्प्रोमाइज पिटीशन भी बना के रखे हैं लेकिन इनके इंफॉर्मेंट के जो ये डिपोजिशन है डिपोजिशन देखने से जो ये पता चल जाता है.
He is somewhere in the court only, Your Lordship, Ladyship, and that is cannot be denied.
Okay. So your first point is there is no specific date, right, of occurrence.
Yes. When I have demanded dowry amount or color TV amount, it was no specific date.
The second point is that there was a talaq khulla by the
khula
wife.
By the informant taken talaq.
What is the date?
1.
Date of talaq. Exhibit 1.
Exhibit 1.
What is the date of talaq?
बीस 4/6
24/2006. What is the date of marriage?
Date of marriage is 13/12/20.
2000.
3/12. What is the date of it's a complaint case?
Yes, complaint case.
Within 2 years.
Date of complaint case was filed in 8/5/2002.
8/5/2002. Number.
Complaint case 50/2002.
2002. Okay. So in talaq khula, she says that she will be satisfied with the money and land. This is what you want to say.
हाँ, तो तलाक लेने के बाद जैसे अब इनके शरीयत के हिसाब से मुस्लिम लॉ क्या बोलता है, इतने बोलते हैं कि तलाक लेने के बाद लेडी अपने हस्बैंड के साथ नहीं रह सकती है, लेकिन उसके बाद भी ये ससुराल में अपने रही, उसके बाद बाल बच्चे भी हुआ।
Well, what is the date of delivery after talaq? So please do not say anything which is not on record because your client is.
Deposition में आया है बात इसमें.
Which deposition? When was the children born?
One children born before her hand was fractured. She left at her.
What is the date? Which deposition are you referring to?
CW1 is informant, and CW2 is her father's deposition.
You say that even after talaq,
she
children
lived
were
at
born.
a matrimonial house.
Children were also born.
Yes, thereafter
So
children.
that is why I want to know that when were the children born? The talaq khula is dated 24/2006.
Yes.
When were the children born?
बोली उसके बाद मेरे दो बच्चे और हुए, बोली हैं.
बस कोई डेट नहीं, वो बोली
डेट
है.
नहीं है, बोली है.
Then
फिर वो डिपोजिशन में बोली कि मैं यह केस उठा लूंगी, उसके फादर भी बोल रहे हैं उठा. हाँ, डिपोजिशन में भी बोली है कि यदि ये मुझे 2-3 डिसमिल जमीन दे देंगे तो मैं यह केस उठा लूंगी. जजमेंट में भी आया, डिपोजिशन में भी आया. पेज 23 में आया.
तलाक होने के बाद 1 साल तक ससुराल में रही. 1 साल में 2 बच्चे हो गए.
बोल रहे हैं 2 बच्चे हुए.
1 साल में.
उसके बाद 2 बच्चे हुए, ये बात आया.
1 साल.
1 साल
जो आपका क्लाइंट बोलता है ना उससे मत.
नहीं, मैं डिपोजिशन की बात बोल रहा हूँ. डिपोजिशन में जो आया वही बोला, अपने से कुछ नहीं बोला. पेज नंबर 23 में ये दिए हैं कि मेरे 4 बच्चे.
जब इनका हाथ टूटा उस समय she had a child in her lap.
9 महीने की बच्चा थी जो अपने वहाँ छोड़ के आई थी.
That's right. That is all. केस करने के बाद भी 4 बच्चे पैदा हुए. तो केस 2002 में हुआ और शादी हुई और तलाक हुआ 2006 में. Right. And after that she remained for 1 year. Okay. What else do you want to say? Any other major illegality? Because there are concurrent findings. Any other major illegality you want to
Court has not taken consideration when it was demanded or talak.
Okay. Oh, that don't repeat. We will take care of that. That is all. The learned counsel for the parties are present. It has the counsel for the petitioner submits that on instructions it was submitted by the on instructions based on instructions received from his client who was present in the court on 16/02/2024, it was submitted that the petitioner and the wife, opposite party number 2, while living together, living amicably for last 2 years, and as they have settled the dispute, please disturb mat kariye. Please amicably settle their dispute. But today he has said that the submission was incorrect when the counsel for the opposite party number 2 has objected to the submissions made on 16/02/2024. He submits that his client is present in the court. The counsel for the petitioner has submitted that whatever was submitted by his client, the submissions was made on the basis of such statement. and therefore the counsel as a person is not at fault. Right? The counsel for the petitioner has advanced his argument. He has submitted that there is no specific date of occurrence with regard to the demand of dowry. He has also submitted that the marriage was solemnized on 3/12/2000 and the complaint case was filed on 8/5/2002, bearing complaint case number 50 of 2002. He has further submitted that the complainant herself had exhibited Talaq Khula within bracket Exhibit 1, which was dated 24/2006, and it was her version that if some money and land is given to her, she would not pursue the case filed under Section 498A and the provisions of Dowry Prohibition Act. The learned counsel has submitted that the evidences before the learned court below has not been properly considered, and therefore the order of conviction is fit to be set aside. That is it. What do you have to say?
देखिए बोले लॉर्डशिप ये 2006 में ये तलाक ली, उसके बाद वो 2010 तक अपने वहाँ रही आया है.
The learned counsel has also submitted that it has come in evidence that
In judgment also.
the complainant had remained
Till
in her
2010.
matrimonial house till 2010. Yes.
The date of occurrence that is saying that nothing has happened, in para 13 of the complaint petition, there is a date 7/8/2002 when this occurrence happened and she was taken to RIMS. Why she was taken into the RIMS? It came in the impugned order also that when she was putting oil to her baby,
She was assaulted.
She was assaulted by the petitioner.
That is it?
That is it, and also, your ladyship, because he went to the custody, and for that reason he is not paying a single money to the opposite party number 2, rather having 4 children. 13 lakh rupees is still pending. Only 1 lakh
For maintenance.
For maintenance. Only 1 lakh rupees has been given on the point that
We cannot
he was,
decide the maintenance case in this case, right? For that you have to file your execution. The learned counsel appearing on
and
behalf of
also my ladyship, prior to that also she has lost a case on 5/8/2002, 2002, and that was
compromised.
That was Adalat in front of the
Adalat.
court that was compromised.
The learned counsel appearing on behalf of the
But then again they have started
on behalf
this
of the opposite parties have submitted that earlier also one complaint was filed, one FIR.
One
FIR was filed by the complainant on 5/8/2022, which ended in a compromise, but still the petitioner did not mend his ways. The learned counsel further submits that the complainant was taken to hospital for treatment on 7/8/2022. This was on account of the assault meted out to the complainant by the petitioner, during which she suffered fracture.
Yes.
He submits that the argument of the petitioner that there is no specific date is not correct. Specific averments have been made in the complaint petition, which was supported by evidences made on the basis of materials on record.
And
The
regard-
learned counsel has also submitted that there are concurrent findings recorded by the learned courts below, and there is no scope for reappreciation of evidence and coming to a different finding. The learned counsel has also submitted that
And regarding 498A also, the finding of the learned lower court is also there that the woman was
the
married.
learned
she
counsel
was,
has submitted that all the basic ingredients for the offences for which the petitioner has been convicted are satisfied in the present case, and no interference is called for. That is it?
Yes, ma'am. The
conduct is
Pose
bad
this
on-
case for judgment on एक तो छोटा सा डेट दीजिए ना हम देखो कौन सा डेट है March.
My last submission,
Yes.
because of the wrong submission that was made yesterday, my client has
What
to
submissions?
my client had to came to the court, and I have verified from the client. She is present also. So might some travel expense or anything, if my ladyship can.
The learned counsel
Any
for the
cost.
opposite party, not at this order, maybe that some cost. The learned counsel for the opposite party has submitted that on account of incorrect submissions made by the counsel for the petitioner on 16th of February 2024. The opposite party number 2 had to come to Ranchi, and she has also incurred certain expenses. From where has she come?
From Khunti.
From Khuti, and therefore some expenses be provided to compensate her. She does not have any. She does not have sufficient source to support herself. Considering the fact that it stands admitted, even from the side of the petitioner, that the submissions made on 16th February 2024 was incorrect. This court is of the this court directs the petitioner to pay an amount of rupees 2,000, 2,000 ज़्यादा हो जाएगा, 1,000
As your
to the opposite party number 2
Only 100
in
rupees
cash
is there.
and deposit the receipt thereof prior to the by within a period of 1 week. The amount of rupees 1,000 can also be given to the counsel appearing on behalf of opposite party number 2, so that the amount can be transmitted to the opposite party number 2.
Obliged. Very obliged.